Since you are not only prosecutor but a lady, I took the liberty to ask to the next two men lawyers to reduce their time, because at 11:40 we need to leave the floor to the next focus. So Peter, with this word, the floor is partially yours.
Let me begin by thanking Laura for inviting me to speak on this panel. I'm very grateful to be on such a distinguished panel. I was wondering what to speak about when looking at the subject of just culture, and I thought the most interesting thing from my perspective of acting for families would be to talk about how families interact with the term just culture. So this is taken from what will be 20 years next year of acting for grieving families. And it's really my perceptions of their interaction with the concepts that we're talking about today. So I guess the starting point is, do families support the concept of just culture? And I think the answer to that is, first of all, that the phrase is something that's unknown to families. It's not a common concept. It's a concept that we work with legally. But I think the meaning behind it is recognizable to them. But the route to the answer to that question is through anger and outrage and trust. And it was interesting that Kata used that term, because I think it applies equally to families, and that's a term that resonates with them. Anger and outrage comes from what they know about the accident and what they grow to understand. So in the most part, they don't think about terms like gross negligence or willful violations or destructive acts. But they do think about intention, they do think about carelessness, and they do think about how a company has responded. I think, first of all, when it comes to anger and outrage, if you look at, let's look first of all at the kind of the airline situation. And I'm predominantly going to talk from an English perspective here, and I know that there are jurisdictions like France where this becomes more complicated, and I think Gregory will probably expand upon that. But from an English perspective, if it's well managed, there's no reason why families need to get to anger and outrage against an airline. They're excluded from the investigation, the Annex 13 investigation. In the UK, the AIB is excellent at managing their information and keeping them updated. The actual investigation report is obviously written in a language which doesn't include, doesn't apportion blame or liability. In England, there'll be the dual investigations. There'll be a police investigation that is undertaken at the same time, but more often than not, there isn't some criminal liability behind, and that police investigation does close down. So there isn't the information that comes out through the media that kind of incenses them. I think that as their lawyers, it's not necessarily in their interest for me to go hunting around to try and find criminal liability. There could be insurance implications for that. And that, together with a strict liability regime under the Montreal Convention for these cases, means that unless they start arguing, the airline starts arguing that there's some kind of limitation of liability under that convention, then we can actually make our way through that process with the families actually just understanding that it was an accident and not seeking some kind of retribution. Of course, if there is clear evidence of willful violations or intention, then the families want those perpetrators punished. But that's in line with the just culture policy, so I don't think there's any difficulty there. I think perhaps where the tension exists is in relation to gross negligence, in circumstances where there's maybe no strict liability regime or there's punitive damages on offer. As a lawyer acting for families, there could be good reasons for me to start to explore and dig in those circumstances. There's no commonly agreed definition of gross negligence, but I think the routes to gross negligence might be said to take us through negligence in determining that standard of care, and then in terms of the breach, into the kind of the depths of how poor that actual breach was. So for a litigator, that's a path and a target, and we're going to follow it. And if it leads to evidence of gross negligence or worse, then so be it. And my job is purely to bring that evidence to light, but I recognize that in doing so, it does invoke anger and outrage amongst those family members. But I think from my perspective, the core framework for just culture to succeed requires aviation enterprises to do two things. The first part of this kind of just culture phrase is that they should properly deal with these minor negligence actions by investigating, changing processes, improving safety. But that is a process that happens behind closed doors. It's a responsibility given to aviation enterprises to complete that process successfully. The second part of this is that they should not tolerate instances of gross negligence, willful violations, or destructive acts. And that's an acceptance of a process that's acted out in public through the prosecution. So for families, if B is not followed, then they can't trust the company to do A. So I just want now to just give two examples very briefly of where I think it's gone right and where I think it's gone wrong. The first example is the Shoreham Airshow disaster. You can see the catastrophe in the background of this. This was a 22nd of August 2015, a bright sunny summer's day. A Hawker Hunter was performing an aerobatic display. It crashed on the A27 Shoreham bypass, killing 11, injuring 13, including the pilot, Mr. Hill. So my firm acted for the families of those killed and the vast majority of those injured. There was an AIB investigation that was commenced alongside a criminal investigation investigation by the Sussex Police. The AIB investigation concluded and the inquest commenced, and partway through that inquest process, the Sussex Police announced that they had charged Mr. Hill with 11 counts of gross negligence manslaughter. The inquest process was stopped and the criminal process continued. After an 8-week trial, a jury unanimously acquitted Mr. Hill of 11 charges of gross negligence manslaughter. Of course, for the families, that outcome was extremely upsetting. The inquest resumed and the coroner concluded that the death of those 11 individuals was caused by unlawful killing. And the reason for that conflict is because of the different standard of proof in the inquest versus the criminal process. Following the inquest in October 2024, Mr. Hill applied to have his license reinstated. The CAA refused, and Mr. Hill took them to court, and a few weeks ago, the High Court affirmed the CAA decision. So in my opinion, this is a perfect example of just culture correctly applied. The actions of gross negligence were not tolerated by 3 separate processes, and it doesn't matter that ultimately Mr. Hill was acquitted. The process was followed correctly. The second example is the Boeing 737 MAX saga. So on 29th of October 2018, 189 passengers and crew lost their lives on board Lion Air Flight 610. 6 months later, a further 157 people lost their lives on board Ethiopian Airlines 302. I've really only included the Ethiopian Airlines investigation here because that was what triggered a lot of what followed. The safety investigation was underway. While that was underway, there was a parallel investigation undertaken by the Department of Transport Office of Inspector and the FBI. And on 7th of January 2021, as our news channels were flooded with images of violence in the capital, the Department of Justice quietly announced that they'd entered a deferred prosecution agreement with Boeing to resolve criminal charges relating to a conspiracy to defraud the FAA Aircraft Evaluation Group for a sum of $2.5 billion. In May 2024, the Justice Department concluded that Boeing had breached the deferred prosecution agreement, and I will rush on. But ultimately, in December 2024, following a further agreement to plead guilty, the Judge O'Connor stated that Boeing's crime may rightfully be viewed as the deadliest corporate crime in history, and stated that he rejected the plea agreement. Finally, in March 2025, after a change in administration, Boeing negotiated with the Justice Department to enter into a non-prosecution agreement in exchange for a payment of $1.1 billion. No one will face prison time, no one will have a criminal record. This is 4 weeks before they were meant to commence the trial. Now, as a kind of concluding remarks on this, so irrespective of the US Department of Justice or Boeing's motives, this decision to drop any criminal prosecution in exchange for money It looks like money and power enables companies to sidestep criminal accountability. The optics of it is, in my opinion, all wrong. It does not look like criminal actions being not tolerated. It doesn't look like just culture. At the outset, I asked, do families support the concept of just culture? And you might say it doesn't matter, but for me, the reason it matters is about public outcry. Public outcry is the enemy of an effective just culture process, and anger, outrage, and a loss of trust leads to this public outcry for families. So my humble opinion, it shouldn't just be families calling for full prosecution of Boeing managers in the deadliest corporate crime in US history. It should be everyone in aviation who believes in just culture. Thank you.
And now I am between my friend Gregory and my friend Mia, so I will ask not to abuse, because we have to leave the floor to Mia and Linda. So, having said so, please.
Well, the good thing being the last to speak in the panel that you can scrap most of what you prepared because I already addressed it. And basically what you said was very interesting for me, so I would change most of my presentation and just discuss. And also, I was a bit surprised by your presentation as a plaintiff's lawyer, because I will be a bit more aggressive against just culture than you were. Even if I'm an airlines lawyer, working a lot against manufacturers, so it's maybe why. As you say, just culture is, and you are very clear about that, is honest mistakes from staff should not be punished, basically. My view is that it's a very important, it's a cornerstone concept of aviation law, of aviation more broadly. It is quite a limited concept. It's a limited concept, maybe not in the Netherlands, from what I understand, because you, as a prosecutor, take it into account. But it's a limited concept to labor law or regulatory fines, etc. And the whole question is, when you actually come to liability, whether civil or criminal, is this concept still important? Is this concept still there? And is this concept, should this concept be included in the context of civil liability or criminal liability, or should it not be included? Because if it creates some unaccountability, it maybe the whole purpose of just culture just falls down. Because if people are not liable at the end of the day, whether civilly or criminally, maybe they don't feel that they have to report, or they don't feel they have to do their work properly. I know that you would say probably, yes, they did, but I'm a bit pessimistic on that. So when you come to civil liability, for example, I think there is a difference between airlines and manufacturers when it comes to just culture. Airlines, they are subject to the Montreal Convention, as you said, and basically whether just culture or not, you don't care on civil liability. Airlines pays up to the limit of the Montreal Convention or not. This is another debate. When it comes to the manufacturer, it's quite different, because manufacturers, well, when you think about a major loss, you have to think globally. You have many nationalities, you could have a lot of jurisdictions involved, like if you take Air France 447, it was 32 nationalities, 18 jurisdictions involved with 18 different laws applicable to the claims, depending where you are. And all these jurisdictions, unfortunately, some of them just don't know the concept of just culture, the judges, civil judges. But as a manufacturer, your product liability, you can have a strict regime like in Europe with some defenses, you can have a tort liability, etc. And this is where the just culture finds its limits, I think, in terms of civil liability. Because can a manufacturer say, okay, well, I'm not liable because there is no gross negligence, or there is no willful misconduct? Maybe in the relationship between the airline and the manufacturer that would be dealt with in the contracts, but with regard to the plaintiffs, I am not sure it should be the case. I think it's something else. And when you now come to criminal liability, I think it's even worse. And I was very interested about what you said about the UK and the fact that it very rarely end up into criminal investigation or criminal trial in France. any major loss or every time you have a death in an aircraft, you can be sure, like 90% of the time, you end up with a criminal trial. Whether it's a major loss or a small loss. And in Italy, my recent experience, is quite, it's the same, and it's even worse, I would say. And criminal liability in France is very easy to find. You don't need to have gross negligence. You don't need to have actually infringed some regulation. You just need to have been careless, imprudent, or just negligence, and you fall. You can be convicted of manslaughter, involuntary manslaughter. And my experience in France for the Yemenia crash, for the Air France 447, and for many others, except the WCA one, which is a bit different, but for all these major losses, plaintiff's lawyers, they go straight to the criminal court. Because when you go to the criminal court as a plaintiff lawyer, for the airline or for the manufacturer, it's much more important than civil liability, which is insured. They don't care, basically. And so you are more likely to settle. And you are more likely to settle at higher amounts. And this is why now in France, we have criminal cases in the Air France 447, so the appeal will take place in October, November. The Yemenia crash, the appeal took place last year. And when you come back to just culture, I think, frankly, the judges don't even know the concept. They do not care about the concept. And it's a huge difference between France, and I'm speaking about France, but maybe Italy and a lot of other countries. The public prosecutor in France for the Air France 447 and for the Yemenia crash was a terrorism judge, public prosecutor. So no experience at all. It was his first aviation case. The judge, the president of the Court of Appeal, was hearing the case in the Yemenia crash. She used to be a judge for small burglaries or this kind of stuff, okay? She had no experience. Well, she did once a car accident, okay? And no experience at all, okay? And she was there with the Yemenia crash. And she will be the same one doing the Air France 447 crash, okay? Based on her experience on the Yemenia crash, which honestly is not a great result for her, but anyway. And just culture is out of her mind. She doesn't care. It's criminal liability. And I know that I need to be short. For me, and I think it's very important for everyone in the room to think about it, that just culture is okay, it's at ICAO level, it's EU level, etc. But at the end of the day, if you're a manufacturer, if you're an airline, and you want to rely on just culture, forget it in most of the regions of the world. That just won't happen. That just won't happen. And just culture is important, but at the end of the day, liability will prevail over just culture. Whether it's good or not for safety, I leave it to you to think about it. My views is that it is, because accountability, liability is a much stronger element for safety than just culture. That doesn't mean just culture is not important, but only on a very strict, limited basis. Thank you.
Thank you, Gregory, and I guess we could continue for hours to discuss about just culture, different regime, but we need to leave the floor to the next focus, which is very, very topic now after, as in this morning has been already said, all the news, the potential reform of 261. So I call on this stage the co-chair of the next focus on passenger experience and legal issues, Mia Wouters, who's a very famous lawyer in Belgium, experiencing in aviation, and Linda Ristagno from IATA Geneva. Floor is yours. Thank you.
So we're starting our next session now, and we got only 80 minutes left. I'm pushing the button right now. Our 80 minutes start. We are going to speak about the passenger's experience, and we will have like two separate chapters here. The first chapter is like the airports. What do the airports give to the passenger? And the second one you will see is more around passenger rights in Montreal. Linda, I think you are going to call your panel to the stage.
Yes, thank you so much, Mia, and good morning, everyone. We will take a little bit of different angles today. So to start with, we would like to look at airports as first port of entry in destinations, in countries and in destinations. So I would like to call my panelist, Alessandra Priante, President of ENIT, Michael Tegedov, Legal Counsel and Attorney at Law at Munich Airport, and last but not least, Marilena Blasi, Chief Business Unit Commercial at Airporti di Roma. So. Yeah, no problem. So, as I said, we will start with a perspective from airports, and we will not really touch base on the legal perspective, but more from a passenger experience, because what we are without passengers, right? And I would like to start with Alessandra. Alessandra, you are the only one here representing the tourism industry, actually. And what do you tell us? What is your strategy? What is the Italian strategy, first of all? But you also have international perspectives, because you have been with the UN Tourism for many years. One of the most representatives, actually, persons at UN Tourism, and working on code of conduct and some sort of legal framework on the support of passengers, of travelers mostly. So what do you tell us? What is your experience and what is the strategy of Italy in terms of supporting or in terms of working with airports and so on and so forth? I know that you have an interesting story to tell us. Please go ahead.
Thank you very much, Linda, first of all, and thank you to Avvocato Pieralini for including me in this incredible set of panelists. And it's good to see some friends as well sitting at tables. I quite enjoy being the white fly. I like the idea that I'm the only one representing tourism, the tourism sector, I would say, the tourism institution, because I think I represent the motivation for all of this to happen. I represent the motivation to travel, and I represent basically the engine that activates the majority of the air traffic, not only, but it's fundamental. And it's completely the same thing as two sides of the same coin. So, and thank you, Linda, for actually recalling my experience in the UN Tourism. When I was in the UN Tourism, immediately after COVID, we started with the International Code for the Protection of Tourists, because clearly air connectivity was considered as the biggest responsible for not being able to manage, and the absolute uniqueness of the pandemic and the effects it had. And so it was a clear target for everyone that were asking for refunds, reimbursement, how to manage, how do you share the information and everything. So it basically, the economy sort of, academic approach, we would say that it was the scapegoat, and it was the target of every single demand. Now, why it is important to consider tourism and why it's important that, and I feel very grateful that I was included, because, as I said, tourism represents the motivation to travel, but the experience of tourism starts in the moment you land. It is important to take your flight and to travel with the best airline in the world and to have the best experience on board. And, you know, but in reality is when you reach destination, airports are the first gateway. They are the first welcome point. They are the first impression collectors, okay? So what I have in the background is something very boring for you, which I'm not gonna scroll, you know, very, I would say, very lengthily over it. I'm not gonna do podium, and I'm very grateful for Linda for actually having this as a conversation. But as well, it's in Italian, so, you know, half of you might understand, the other half not, so it doesn't make any sense. But I wanted to carry you through what we have prepared. Because what we've done, you were asking about the strategy. We've done a review, okay, of what happened, and this is going to be available as well, translated in English, when, you know, the birth of the rights and the necessity for a regulatory framework which could be shared and not only apply to the air transport, but to be extended to more of that. So we, being European countries, clearly we are protected in a way by the European framework. And now I would like you all to consider that we, for the first time, we have a European commissioner that is focused on sustainable transport and tourism. It's the first time tourism is mentioned in a portfolio, which is an absolute unicum, and it's just maybe the recognition of many, many years of work and lobbying. So when we look at all the effects clearly, we look at a regulatory framework that has taken into consideration the passenger in a very thoroughly perspective. But again, when pandemic happened, it was clear that there were many loopholes. So there is clearly a new set of norms put in place. There is clearly a level of, let's say, coverage for any other incident. We were mentioning, you know, plane incidents, but we can also look at small things like lost luggage or, you know, luggage sent somewhere else. And most of all, the rights of people with reduced mobility. So the fact that, you know, there's a huge chunk of people that have a disability, which could be temporary as well. It doesn't necessarily need to be permanent. And so how is that treated? So the rights of the passenger, the rights of the tourist, if you allow me, are widely covered, but clearly they require more and more intervention, because now, when I was saying airport, first point of arrival, first touristic experience, it is true that when we look at the experience of traveling, it is dramatically important to be, you know, aware of the rights and aware that the airline or the airport are giving you that kind of support. But clearly, it is important that airline and airports are completely integrated in this approach. So the customer experience, the tourist experience, requires that type of dialogue. And tourism is all about that. Tourism is an horizontal sector that requires horizontal dialogue, because this is the way you can actually activate a lot of advantages, and you can actually, you know, focus on how to overcome the threats, eventual threats that can be available. And we have a national strategic plan that we drew in 23, expires in 27. We're not a unique country in doing it. Everyone has a strategic plan. But in our case, we wanted to focus on some key words that can easily be reflected and should be also guiding landmarks for air transport, which is sustainability, innovation, and accessibility, directly deriving it as well from Agenda 2030. And the importance of good governance and good data. So I'm going to stop right here, Linda, so that you can pass over to my fellow panelists, but I'm ready to get back to you on this.
Of course. Thank you, Alessandra. And I think governance of tourism is important. And I totally agree with you that having a specific focus on tourism, not only on transportation, is relevant as well. And you have been one of the biggest advocates, I remember, in your previous position about the recognition of tourism as an horizontal industry for the experience of the passenger, not only for the rides, so talking about rides themselves, but also for the true experience of the passengers. And we will go back to that, because I also want to listen from you on what do you think will be the role of DMOs. But first, I have a question for you, because as Alessandra was mentioning, airport is the port of entry, and where the customer experience and the passenger, or for us it's the passenger, but actually it's the traveler experience really starts. So, Marilena, I would like to understand from you, in terms of Aeroporti di Roma, what is the vision and the mission, and the scope that guided your commitment to make this customer experience satisfactory, and not to have only the customer, but look at this customer as a person and as a traveler, to make sure that they come back again, actually. Thank you.
Thank you, Linda. I asked to put the presentation that I prepared, and
if we can go, please, to the next.
Can I have the slider? Thank you. Thank you for your question. And I can confirm, as Alessandra mentioned, that the airport is the first step of the passenger. And then we try to provide an experience making the airport not only a transit point, but a real, intelligent and integrated ecosystem for passengers. Then, what we do in the last years, we do lots of activities in order to increase the capacity and to make this experience in the airport innovative and smooth and also enjoyable for our passengers. We have put in place a lot of initiatives. And regarding our strategy in order to improve the customer experience, our strategy is to move to fragmented waiting area to centralize the strategy and centralize the airport, because in this way we could concentrate the services in the centralized area, and we can improve the passenger flow and offer services following the need of the passengers and in the moment in the passengers are most needed. Then, just to give an example, we have implemented the work area, we have implemented a family area, pet area, digital information kiosk, premium seats, in order to provide a very enjoyable experience when they wait in our pier. And we do this making the security control, the boarding activities, and all the activities related to the travel very short, in order to provide the best experience in this centralized area. Then we have also transformed our pier in a real art gallery. We had some masterpiece from Bernini, the final work Salvator Mundi, and we have also a gallery dedicated to an exhibition coming from Ostia Antica. And then in this way, we enrich the experience of the passenger in the airport. And then this is the last news for us. And then we have recently released an hotel dedicated to our friend's dog. And is a very funny and enjoyable experience for our friends. And the passenger can leave the dog in the airport, and then they can pick up when they come back. So on commercial side, the implementation of this strategy is this. We have two main areas, two main galleries, one dedicated to Schengen area and the other one dedicated to extra Schengen area. We have more than 200 shops, 200 retailers, and we obviously privilege the Italian brand, including top luxury brand. We have two whole food market, and also in this case, we valorize the Italian gastronomy. And then we have also implemented on commercial side tailored services. We have a team that can recommend brand, can reserve products, and this team speaks 4 languages, including Chinese and Korean.
Thank you. And from infrastructure perspective, and then I will come back to you. This is interesting in terms of what's happening to improve the customer experience, of course, but I also wanted to listen from Michael. What are you doing in Munich in terms of expansion and in terms of improving the infrastructures themselves? As you wish. Yeah.
So maybe the next presentation, yes. The one that's the correct one. Good morning, everyone, also from my side. Thank you. So we've heard a bit about the challenges of the future for our industry. SAF was mentioned. We've heard about digitalization here at Aeroporti di Roma. But we all must keep in mind, and thank you for including me as an airport representative in that context, that also for the foreseeable future, air transport and in particular airports will continue to run in analog mode. So we need solid and tangible infrastructure to make all this happen, what we've just heard also from Marilena. So I will talk a little bit and try to focus on the main aspects of the legal challenges we've had in recent years at Munich Airport with regard to the expansion of our tangible infrastructure. First, a very brief background regarding Munich Airport. We are entirely held by the German state, different entities of the state. The majority lies with the Free State of Bavaria, and also the Federal Republic of Germany and the city of Munich hold shares. That does make it difficult at times to reach decisions, in particular from a commercial point of view. The airport at a glance, we're not going through all of these figures, but I would like to point out the number of movements we had in 2024, 327,000, and the number of passengers of 41.6 million, both figures still significantly lower than what we had in 2019, the last full year of operations before COVID. So we are still about 15% under that capacity we had in 2019, and we're still trying to recover that ground. We are traditionally rather well connected to the world, with many destinations directly connected to Munich. And as you may know, we operate as a hub airport and thereby contributing to sustainability in reducing the number of flights necessary to reach a certain destination. So I would like to focus on the efforts to construct a third runway in Munich. We've operated 2 runways since the opening of the airport at this particular site in 1992. However, when the shareholders sat together very early in the 70s and made plans for a new site of Munich Airport, they already had in mind a 4-runway airport. So it was clear that at some point an extension was necessary after the first 2 runways were built to take up operations. And the concrete planning phase for the 3rd runway started in 2005. And as you can imagine, many different areas had to be considered: zoning law requirements, cost-benefit analysis, which had to explain to the shareholders, the traffic forecast, for example, and that's why I stressed the current passenger figures earlier. The traffic forecast we had at the time foresaw for 2025, for example, 58 million passengers at Munich Airport. So we are substantially lower than that. Obviously, nobody expected the pandemic taking place in the meantime. At the time, all different levels of, let's say, public entities, policy entities, such as the European Commission, saw the necessity of substantially expanding airport capacity all over Europe. That also was true for Munich Airport, and that's why we received a green light from there. So let's have a closer look at the intended runway. You can see here a nice aerial view, and in graphics it looks like this. So what we will have in the future, and I'm still confident that we can implement it sooner or later, what we will have is the extension to the north and east, with a 3rd runway that will have all the requirements even for large aircraft. Interesting to note in this context is that in Munich, compared to all other German airports at least, the number of people affected by noise emissions of the airport is substantially low. And even if the 3rd runway would be implemented or will be implemented, even then when it will be implemented, there will only be about 4,000 people additionally affected by noise emissions. Nevertheless, in the context of the discussion, particularly in the public domain regarding the implementation of the project, these emissions were overrepresented, and it was a huge argument for the opposing side to win over the population and oppose or stall the project for the time being. Many different stakeholders had to be considered. We won't go into that. Maybe this is an interesting slide. The typical noise carpets that aircraft produce nowadays are substantially smaller than what we've seen in the past. Still, the popular vote at the time when this referendum was held was against expansion of the airport. So, to put this in context, this referendum was held in 2012. What was asked? Or who was asked? The citizens of Munich. You must know the airport is located 40 kilometers away from the city center in a small community. However, people affected directly by the airport were not asked what they thought of the project, but the city of Munich was asked, the citizens. What were they asked? How the city as a shareholder should exercise its voting rights in the shareholders in the shareholders meeting. So what did they say? They opposed the project by about 54 to 46%, and only about 35% of the population took part in the vote. And the binding effect was not, oops, typo, 12 years, no, just 12 months, but where are we now? We still have no third runway. Because since then, the political side, and I mentioned the public shareholders in the beginning, have shunned to take responsible decisions. And we're not in Germany, so I may be able to speak a bit more frankly than I would do at home. This is a very sad situation. They are elected to take responsible decision for the common good. What do? They render the question back to the population in a referendum that is binding only for 12 months, and then they say, oh, yeah, okay, noted, and they simply won't act later on. So for about 6 or 7 years, we are now being governed by a coalition of the Conservative Party and some movement that developed into a real party, which is called the Free Voters, who, and the latter, substantially formed the opposition against this third runway project. So there's now a moratorium for as long as this government stands.
Michael, we have 3 minutes.
Yeah, I'll close in a minute. The legal battles on our way to the third runway were all fought and won. 22 claims against the project, all rejected. So from a legal point of view, it's basically untouchable. Also confirmed by the Supreme Administrative Court of Germany. So that's where we stand after 20 years of planning. As I said, this latest coalition government has issued a moratorium, and we'll continue to fight for the third runway, and fingers crossed we'll realize it still in my lifetime. Thank you.
Thank you. Thank you very much, Michael. Very interesting perspective in terms of infrastructures and also the impact that it may have in the population. And specifically on this and on what Marilena was mentioning in terms of strategy, I wanted to make not really a link, but I wanted to ask Alessandra. So we have seen infrastructures, we have seen strategy, but what do you think should be the pillars on which a proper policy of tourism, of travel and tourism should be built? For the benefit of everyone.
Great. Thank you very much, Linda. I think directly deriving from what we were saying and talking about good governance, I think it is absolutely paramount that every player of the sector understands that we all must come down and sit down on a table, because the silos experience doesn't work. Therefore, Aeroporti di Roma, I'm just quoting this example because she's sitting right next to me, an airport that I personally use a lot, so I can actually confirm and also give some other feedbacks, but it's okay, we'll do that in private. But the great experience in Aeroporti di Roma then needs to match whatever happens outside. So the second step is intermodality. Okay, how do I get from airport to center? Some cities, like Madrid, they're 15 minutes away from the center, super connected with 3 types of transportation and taxi, and with a fixed rate, by the way, protected by the government, and Uber or anything else, and clearly private transport. So in our case, we need to make sure that when people get out of Roma, whether they're reaching Roma as a destination or that it's just a stopover going somewhere else, then of course if it's a stopover, it's entirely on you. If they're coming out, which is what concerns me as a tourism board, we need to make sure that all the rest that happens is seamless, is consistent and coherent, and doesn't have any hiccups. Otherwise, we're disrupting the passenger experience. So the passenger experience that begins at source market is actually a continuous journey. So you step into Roma, you have your experience with the luggages, everything goes smooth. They're not late, the luggage is okay, people are nice, there's an information point, there's, toilets are clear, where to go, whatever. So I'm coming out, and then what do I do? If I'm not organized, what do I do? Where do I go? Okay, I can go here, there. So it is important that it's the door-to-door experience. When door is my exit door at my house, and door of entry at destination, which is, in the case of going from one bed to the other, for example, hotels. So how do we make sure that every player that sits on the table is actually putting enough attention to what this is all about? Because from the consumer's end, there's no disruption. The consumer doesn't understand that airline is airline, airport is airport, taxi is taxi, municipality is municipality, metro is metro. It's like, for me, is everything all connected all together. And at the end result will be a destination evaluation, an experience evaluation. So we're all part of that experience. And I always say in my classes where I teach in university, that I keep on reminding that tourism is not about going, it's not about reaching a point from point A to point B, it's repeating. And it's about telling as many people as possible that it's worth the trip. And I cannot just go to a destination because I completely enjoy flying with a top airline that gives me, cocktails for free in the upper deck. I need to make sure that everything that I do makes sense, which means, Linda, that when I say not work in silos, everyone must be involved. I am incredibly happy to be, the white fly in this panel, as much as I'm happy, and thank you, Laura, for that, for the attention of women to men balance. I love you. You're one of the few conferences where, I'm not, normally I'm the only woman surrounded by men in this country, so, really congratulations on this. But what I'm saying is that we must include destinations, destination management organizations, cities, hoteliers, we must include them in the conversation. Because at the end of the day, if, let's say clearly all of you are profit-making companies, right? Airport is making profit, airlines making profit. So you are relying on customers, which are the travelers, okay? And I'm the one who's supposed to motivate them to come, right? I attract tourists, especially, you know, long-haul destinations. That's what I'm really interested in, but also short, why not? But what I'm saying is I need to guarantee for that trip to happen, I need to make sure that the experience is in all these compartments is worth the travel and the money. And on your end, clearly, the customer satisfaction is very important to guarantee yourself that, for example, your planes are full, you're opening new routes, and you're developing new services as it's happening now, for example, in Aeroporti di Roma. By the way, congrats on the dog relay. I'm gonna have to try that soon. So what I'm saying, Linda, is that it is important as a paradox, and we were talking about it yesterday. I'm very well known for dropping bombs a little bit here and there. So Laura, if you allow me. I do encourage airlines especially. I mean, airports are already doing a lot. Like they, for example, have a hotspot in Termini station. They're trying to connect themselves to the center of the city, which is great. They're trying to offer services from the airport to the city, so which is, you know, a great step ahead. But what I'm saying is, I would like to talk to airlines right now. How many of you are representing airlines? Ooh, good, excellent. I'm gonna have to find you to get some personal discounts later, but it's okay. Is anybody from TAP here? Portugal? No? Damn it. I'm gonna have to continue, you know, highlighting Emirates all the time, not joking. ITA, all my life, okay? So, what I'm saying is, start considering to have an expert in destination management in your airline. I know you're lean. It's a lean business most of the times. It's like, I'm filling up the plane, I'm going from point A to point B. Maybe I'll expand a new route, especially if airports give me incentives. But it's very important, if you're developing your product, to also have the expertise in-house to make sure that whatever you're doing makes sense and to get the best out of developing new routes. Because at the end of the day, you're gonna find yourself incredibly like a real protagonist of the whole value chain and much beyond. And trust me, the benefit that you're gonna get out of this is absolutely, absolutely relevant.
Thank you, Alessandra. So what you're saying is that we need a policy of tourism. So we need to have tourism as part of the airlines' work to develop, and we need destination management, a sort of
you need good, as I repeat, I think we need good governance, which
Yes.
means that, you know, the complexity of dealing with different levels of admins, which is national, regional, local, whatever, and we're experts in Italy and multiplying that. But yes, you need that type of approach, but you also need very good data and a quality service focus on making sure that tourism, the experience of tourism is part of the discourse.
Thank you. Yes, yes, yes.
Panel, but there was like 4 more people to come.
Yes, I just
so-
want to wrap up, if you don't
Yeah,
mind, because
can you
yes,
please? Yeah.
with data, I just want to wrap up very briefly
No,
because
no, there's really no time. I mean, we should respect a little bit each other, I think, because there was 4
Okay.
more speakers.
so
To her thing, I just want to say that maybe I mean, even previous panels were much longer than us, so I think I mean, let's honor these fantastic
We had
women
80
here.
minutes, and so.
thank you.
I'm not
Thank
going
you.
to discuss this, just, you know.
Yeah, yeah. No, it's just to wrap up because also Aeroporti di Roma has new digital initiatives because Alessandra was mentioning to data. I think that data policy making based on data is important, but also digital is one of the pillars of aviation right now. And I know that you are also developing some digital initiatives very briefly, and then thank you very much. Very briefly, very briefly.
just 10 seconds in order to have a wrap up, only to remark that Aeroporti is strongly involved in order to innovate and digitalize the experience. I would mention only two services that we have implemented. Digiport, it's a suite of features that provide information, that provide real-time offline information to the customer, and also provide digital map in order to have orientation in the airport. And then we have also developed a digital suite in order to reserve table, to reserve products in our retail, and you can also use this service and pick up when you go to the pier. Just to say that this innovation is crucial to improve operation in airport and to improve the experience.
Thank you very much.
Yeah. Great panel. Because as was said, the experience actually of the passenger starts in the airport, but now we go a little bit more to the real experience of the passenger. Thank you, thank you, thank you, thank you. So I'm calling now to the stage Claudia Hess. I've got 4 lawyers. I must say I've got 4 lawyers now for you. Claudia Hess, a lawyer from Germany. Sergi Jimenez, a lawyer from Spain. Michael Lustenhauer, a lawyer from the Netherlands. And Diego Almedo, a lawyer from Spain, again. And Laura, thank you very much for organizing this. And as already was touched upon, you will see there is a lot of women again. I never understood quite well what was meant by the balanced approach, but I think we achieved the balanced approach now with all those women. And I'm going to give right away the floor to Claudia. So we also, come. We changed a little bit the titles because, as you know, like last week, the Council came out with a proposal on the new 261 regulation. And the speakers just wanted to speak a little more about TEN-10 on the travel package. And I'm sure they will deliver content. So, Claudia?
So thank you, Mia. Thank you, Laura, for including me in this wonderful conference again. As Mia just said, this panel is going to be a little surprise because we're not going to speak about package travel, but because of the recent developments last week, which are very topical, we have changed the theme of our panel to passenger rights and the reform on the Regulation 261. Of course, this was all agreed with Laura, so no surprises for her, but maybe for you who have intensively studied the program. So I will firstly walk you through a little bit of the history of Regulation 261. Actually, it could be a very quick walk or a very long one, because as you all know, the regulation on passenger rights came into force on the 17th of February 2005. Then in 2013, because it became very well known to all the stakeholders, especially the airlines and also then the Commission on the lawmaking side, that there are a lot of shortcomings to the regulation and that adjustments would need to be made, more adjustments to meet the practical needs. But then, unfortunately, this is why it could be a very long walk to history, which I will spare you. There was many years, even more than a decade, of a political blockade. But then now, in 2025, last week actually, the Polish presidency of the Council expedited the reform. So last week, there was an agreement on a compromise of the regulation wording, which of course has not yet led to a new wording to come into force, but there was at least the first step that has been taken. So later this year, there will be a decision of the European Parliament as to whether the new wording will actually come into force or not. I will show you a few of the landmark changes that may come into force or not, but at least you are aware of what could happen in the future in terms of Regulation 261. So as you all know, in terms of compensation, now we have 3 types of, or 3 amounts concerning 3 different lengths of delay at the final destination. So 250 euros, 400 or 600, depending on the length of the delay. So that is now, and new could be 300 euros for delays or cancellations of flights up to 3,500 kilometers, as from a distance of 3 hours, a delay, sorry, of 3 hours. And the second threshold would be a delay as from 4 hours, which would only be 500 euros. So the amounts have decreased. The next, topical issue is extraordinary circumstances. So currently, we do not even have a definition of extraordinary circumstances in the regulation. So all we have is case law that has been, created by the European Court of Justice, but also by national courts. Now, in the new wording, there will be a definition. So it will be a circumstance that is not inherent in the normal exercise of the activity of the air carrier concerned and are beyond its actual control. And the new regulation will even contain an annex which will include an unexhaustive list of extraordinary circumstances and also a rather short list of circumstances that will not be considered as an extraordinary circumstance. To show you some of them, we will firstly have weather conditions, whereas the annex will not show which exact weather conditions will constitute an extraordinary circumstance or not. We have also damage to the aircraft due to weather, whereas certain situations are shown which could cause damage to an aircraft, such as lightning strikes, hailstones, thunderstorms, severe turbulence. Also, capacity restrictions or airspace closures, so that would be ATC measures, could be an extraordinary circumstance. The strike of essential service providers, this would be ATC strikes or ground handling staff or other players that are external. And interestingly enough, also crew strikes, which are currently not an extraordinary circumstance, would be considered as an extraordinary circumstance under the new wording, provided that the reason for the strike is outside the responsibility of the airline, for example, retirement age or anything that can only be addressed by public authorities. Again, a new feature would be that crew sickness or the death of crew could be considered as an extraordinary circumstance if the crew member is sick or passes away outside the airline's home bases. Also, technical circumstances, which are currently not an extraordinary circumstance or only under very limited conditions, could be an extraordinary circumstance, provided that they could not have been remedied during the regular maintenance checks. Another hot topic would be rerouting, so the rebooking issue that is especially critical in Germany at the moment. At the moment, we do not have very clear wording in the regulation, so it only says that the passenger has to be rerouted to his final destination under comparable conditions, which is stipulated in Article 8. And we have some case law according to which the passenger has to be rerouted on a direct or indirect flight and on comparable means of transport. So now, what is new? There are several options of rerouting the passenger. The passenger can be rerouted on the same route. He can be rerouted on a different route, including to or from alternative airports, whereas the airline has to pay the costs of getting the passenger from the alternative airport to another airport. Rebooking has to be made also to different air carriers, and, which is a little bit unsettling, also on other modes of transport, for example, train or bus. And if the passenger is not offered a rerouting within 3 hours, the passenger will have the right to arrange his own rerouting, and he will receive a refund of up to 400% of his initial ticket price if he takes care of his own rerouting himself. So the last slide, in the interest of time, very, very quickly, a few new features that are also included in the new wording. There will be free of charge spelling corrections. If you have a typo in your name, then up to 48 hours before departure, you are entitled to have your name corrected without having to pay. Then we have the new feature of tarmac delay, which means a delay of more than 30 minutes sitting in the aircraft on the runway. The passenger would be entitled to real-time updates on what the reason is for the delay and how long it will still take. He is, sorry, yeah, it's already there. He's entitled to free drinks and the free use of toilets. And the passengers would be entitled to disembark the aircraft after 3 hours. If hotel accommodation has to be provided because the flight is delayed or canceled, until now it was until an unlimited period of time. Now it's only 3 nights. Passengers have the right to complain, whereas a complaint handling mechanism is installed. The passenger has to complain within 6 months of the disruption, and the airline has to reply within 30 days. And the last new feature is that the refund has to be made within 14 days and not within 7 days as we have now. So we will see if anything is going to change, depending on what the Parliament says. There are a lot of critical indications that this may not come into force, but at least there has been some developments in the development of the regulation. Thank you very much.
Not the time. Could you stay there a few more minutes? Can you stay a few minutes? Okay, I just wanted to ask you something. So, provided that the passenger has to give in on certain of its accrued rights, like the 500, the 600 go to 500 euro. Also, there seems to be a correction of current case law. What do you think, how are the odds that Parliament will approve it, also provided that in the news you only read that everybody seems to be against this? I mean, like, where does this thing come from? Everybody, like even the airlines are against it, the airports are against this. BOIC, which we said already before, is very, very powerful. What is, do you think, why will this pass the Parliament? Because the Parliament is very heavily lobbied by all those stakeholders and also the national, the passengers.
Well, in my view, it could be very critical that the new regulation will pass the Parliament. It's also already in the news in Germany that at least the German representatives are against this because they put passenger rights and consumer rights first. And so, in my view, it may not ever come into force.
Okay. Thank you very much.
We will see what happens, yes.
So, as the next one, it's Sergi. And as you know, like everybody wants to unbundle the products. The passenger will only buy what he wants to buy. Now, then the question arises, what is the standard package? What should be included when you buy a ticket? What has to be included? So Sergi is going to speak a little bit on how luggage is treated within that framework of,
Can we have a quick poll, if you don't mind? I know there are Italian colleagues here. It'll be 3 quick questions. For those who have come to Rome for this conference, flying, taking an airplane, raise your hands, please. I mean, including myself. Thanks. Those of you who, when flying, had a trolley on board, the usual baggage, how many of you did pay extra for that trolley? Are you aware of this? Nobody? Just hold on. Once again, I'm trying to count here. Oh, that's very few people only. Excuse me? Yeah. Well, yeah, that's the issue. The Spanish government initiated about 18 months ago a procedure against initially 5 low-cost airlines. This has now been widened to another 2, and there are talks about maybe other airlines also being targeted. The first procedure against the first 5 airlines has now ended at the administrative level, ended in January this year, with fines. Actually, the figures that we have on the slide are a bit outdated. The total fine ended up being about 180 million euros, of which Ryanair was targeted with 107, Vueling 40 million, EasyJet in the region of 30, if I recall well. So substantial fines imposed by the Spanish Consumer Protection Minister for charging passengers when they want to bring their trolleys on board. I know that this is, we have discussed this at length, for example, with Laura. This issue was settled years ago here in Italy, but we're always a little bit behind in the most southern part of Europe. Now, these cases, all of them, as you can imagine, the airlines have challenged that in court, and they are now in a court procedure in Spain. And the current status of the situation is that the airlines asked for precautionary measures to be passed in two senses. First, that obviously the fine should not be paid, please, until there is a final judgment. And secondly, the ministry, as part of the sanction, also ordered the airlines to refrain from continuing with this policy. And this is a second kind of battleground in this precautionary measure situation. A decision is to be expected in the next months. Everybody was thinking of maybe before the summer season begins. It can get tight. We'll see. But this being a Spanish-only matter in terms of litigation, if you want, in reality it overlaps, it overflows beyond the Pyrenees, because if one country, such as Spain, imposes this kind of restrictions on free pricing, on how the airline should manage onboard baggage, there needs to be a coordination with the rest of the European Union countries. It cannot be that one country regulated in one way and other countries, such as Italy, for example, have now decided differently. So it's a question to be continued. If the regulation, or let's say the new project of regulation, is not approved, then this matter is very likely to be brought to the attention of the European Court of Justice in order to get a unified view. Otherwise, I don't know how it'll work. But the good news, we don't know how it'll pass, but the good news is that the proposal for a regulation passed by the Commission has a proposed solution to this, in which case we'll see what the Spanish judge, who is now charged with this case, ends up deciding, because we're talking about past matters, and there'll be maybe a new regulation coming up. So I think I make good use of my minutes. Nobody's going to kill me, right?
You're a perfect speaker. Thank you so much. Will you please take a seat, and then later on we will ask also the audience, because I'm sure the audience has got a lot of questions now. But next we go to Maaike, and Maaike, I think you will integrate a little bit this luggage problem into the new proposal.
Yeah, let's see if that's good news. I don't know. Do we have my slides?
The slides for Maaike, please. Maaike Wisselnauer. The slides, please.
Okay, well, yeah, and to me, both. But it doesn't matter. So they were just pictures as you're used. So anyway, there was just a picture of what's next. And that is what I'm going to discuss. And maybe to do a quick step back, you might be wondering, if we're talking about a revision of EU 261, why are we talking about baggage? Well, the revision is one proposal for amending two regulations. The number was in the slides. That's 2027/97, and that one is also being amended. In the first proposal of 2013, it was already mentioned that there was already mentioned something about baggage in the cabin, but that regulation said that carriers have full commercial freedom to establish the conditions under which to permit baggage to be carried. The main aim was that carriers should be clear about what they're charging. It's about information to the passengers, but there was still full commercial freedom. Well, obviously that soon changed when there came many amendments by the Parliament. And one of the amendments was that carry-on baggage must be free of charge. And we're talking about essential personal items or belonging, and that is such as coats, handbags, and obviously you need it. It's the bag that you bought shopping at the airport. You need to be able to bring that for free, obviously. And that is in addition to the maximum described hand baggage that you, on the basis of your contract of carriage, could bring. And that must be what kind of type of carry-on baggage you were allowed to bring. That must be clearly stated in dimensions or maximum weight. But the airline could not tell passengers a maximum amount of suitcases or luggages as long as the dimensions and the total weight was respected. Well, there have been much debate since, as Sergei also just told you about, like, do airlines need to allow passengers to bring personal items for free? Should the airline industry develop standards to establish standardized dimensions of cabin luggage? Can they? I mean, not every aircraft is the same. So there was a lot of debate about that, and at one stage it was even included that airlines should allow passengers to bring all their hand baggage, so your carry-on that we were just discussed, your trolley for free. That was later on brought back to luggage with a minimum dimension of 55 by 40 by 20 centimeters, with a maximum weight of 7 kilograms. Yes, they are very specific. And in the latest draft, it is luckily limited to one personal item, and that is defined as a piece of unchecked baggage constituting a necessary aspect of the carriage of passengers, which complies with security and safety requirements with a maximum dimension of 40 by 30 by 15 centimeters, or on condition that it fits under the front seat. For lawyers, this is a feast, because there are so many vague wordings in here. We can litigate on this forever, I think. What does this actually mean? But there you have it. And hand baggage is the rest of unchecked baggage that does not fall under this description. So, yeah, that's the status as it is on hand baggage and personal items. And Laura, I remember you when you once talked about EU 261, you said that we ended up with that regulation because one commissioner was delayed. Well, now I'm wondering that, because there's another item in this new regulation that I want to mention, and I had a nice picture of it, but I'm wondering how we ended up with that, because that's musical instruments. This is so weirdly specific, but now airlines have to strive for passengers to bring their musical instrument into the cabin, because they say that it is of immense monetary, artistic, and historic value. I don't know how they come up with this very specific example that is now included in the regulation, but airlines should strive to, well, allow passengers to bring that into the cabin. If it's a really big instrument, passengers may put that on a seat, but then they do have to buy, no worry airlines, they do have to buy a spare seat, and they're also very specific. Your instrument has to be in the window seat, cannot be anywhere else. I assume that has to do with evacuation, that you can't fall over a musical instrument, but it's oddly specific. So that's it for now, but I wonder what the future will bring, because then if something else goes wrong with some item of a European commissioner, that might end up in there as well. Who knows?
Do you quickly want to go over it? Over your slides? Want to see the pictures? Yeah, maybe you should show the pictures then? No, we... No?
Hello. So thank you, Laura, for having me here today, and thank you, Marco, as well.
Diego was going to do a little bit broader.
Yeah, exactly.
Because
so,
we were waiting for the pictures to come, but there's no pictures, but you are in the picture now.
Good.
So Diego is going to do it a little bit broader, and I think you're also going to speak about liability of the air carrier.
Exactly.
Yeah.
That's the idea. I have 9 minutes, not 19, and 50 seconds. So thank you, Laura, for having me. Stop making this bigger and bigger, because otherwise people will stop going to IATA, and you will be the one doing the biggest event every year. Congrats. So yeah, I'm gonna be speaking about the review as well of the new modification, the if you have read the documentation of that was published by the Commission, you'll have seen that there is a modification of the Regulation 2027, so the mechanism that we have in the European Union to implement the Montreal Convention. So it is incorporating some articles speaking about animals. So that gave me the opportunity to bring the case that we have in the European Court of Justice related to the transportation of a dog that was lost coming from Argentina to Spain. So basically, very quickly, the background of the case is the dog was going to be loaded into the hull of the aircraft, and then it broke the cage, so he escaped. There were 3 dogs, but only one escaped. This was in 2019. So we had a case in the Commercial Court of Madrid, and the Commercial Court of Madrid, following the request of the plaintiff, elevated a question, a prejudicial preliminary ruling question before the ECJ to interpret if the Montreal Convention 99, the Article 17.2, in conjunction with the Article 22 of the Convention, should be interpreted as meaning that the term baggage, either checked or unchecked, does not apply to pets. So the discussion is about the limit of liability when transporting pets. I do know that not all the airlines transport pets and animals, but there are a few that do it. So this is an ongoing and growing trend. People are more and more used to travel and to be willing to travel with their pets. By the way, I'm a dog lover. I have my own dog, so it's not, I have nothing against them, but I'm defending the airline here, of course. So the arguments of the plaintiff are that animals are not sentient beings, which is, of course, yeah, but it is the reality of the thing. We have a new regulation in Spain that is actually accepting this modern concept of sentient beings. So that was used to persuade the court with this idea that the regime of the Article 17.2 of the Montreal Convention should not be applied to the animals, to the dogs, because we love our dogs and our cats and so on. And instead, the regulation that we should apply is the Article 17, which is actually a regulation for persons, for people. So in a way, they are saying, but they do not end up in there, but that animals should be treated as persons when it comes to compensation. So our arguments in defense of our position are that animals are sentient beings, not things. Of course, we are accepting that. We love animals as well. I mean, we all are people. But the regime of the 17.2 and the 21.1 is fully valid, and that animals can be included with the scheme, even though they were not in the mentioned in the preparatory works, even though they were not mentioned in the jurisprudence so far of the European Court of Justice or the other instruments that we have. And we are also defending that we have the ideal mechanism to quantify the damage that one person suffers when the animal is lost or is dead or dies during transportation, which is a special interest declaration. And this is the ideal mechanism because it allows the person to make the statement to the airline, so the airline knows what is transporting, how much do I care, and how much I quantify my moral damage. So there is also another regulation in the European Union that you may want to check if you come across a case like this. It's for the railway industry, and it differentiates things and animals, but it gives them, to both of them, the same level of compensation. So that's actually a good precedent that we have in the legislatory part. We had the hearing in Luxembourg in February, so a few weeks back, and we're expecting the judgment by the end of the year. So all these because it's connected to the modification of the European regulation that was released on the 5th of June, the proposal. And as I said before, the regulation 2027 is tackling on some parts of this dispute that we have. First, the special value declaration. Sorry, first the definition of recognized assistant dog. So it's giving a clear definition of what is a service dog that you can, let me go quickly through it because the presentation must be finished in 3 minutes, I think. But basically, there is a new definition of the service dogs. There is an explanation and a deeper definition as well of the special value declaration, or special interest declaration, and it is explaining that it shall be based on a tariff which reflects the additional costs of transport and insurance for baggage valued. So the legislator is touching these points in this proposal, and then it is also touching in a more detailed way the way that we should value service dogs. So it is including an explanation on how the special interest declaration for service dogs should be made. So that has been defined now, and it's also allowing to have a mechanism to quantify the damage that is caused to a person who lost the service animal. So also actually for the restitution or for the replacement during the time that the person needs another assistance dog. So our challenge here as an industry, and we have seen people here this morning speaking about in the airports, they are taking measures to make sure that people can travel with dogs in a more friendly manner, is that the legislator is not taking action as they should be taking action probably. They should, our point here, or my point here, is that they should be looking at the future. We had here the president of the Civil Aviation Authority of Italy saying that legislators and authorities must shape the future. So they are not doing here anything with regards to the transportation of animals. And people want to travel with their animals. That's for sure. That's increasing. We are seeing that year after year. But it comes with a lot of challenges for airlines that are being ignored by the legislator. So challenges related to allergies, to discomforts, to bites, to related to hygiene, so many things. Also related to safety. As Maike was saying, I was super surprised when I was reading about the musical instruments, and I was like, how many people do travel with their float or with whatever, and they travel with the dogs? So they have been focusing on that, and it's a bit absurd. We also have already in Europe the experience of the US, where they had this American with Disabilities Act attempt to modify the regulation and the scheme, and it was pretty chaotic, and actually they had to go back and suspend all the modifications that they had made. This modification is probably not gonna see the light at the end, as my co-panelists were saying, because it's apparently all the parliament structure that we have nowadays is not gonna pass it. But this is definitely not enough, and we should have a more complete approach that is actually taking a look to the real needs of the industry, taking a look to the real needs of the passengers of the airlines, and helping us to shape the future. Because otherwise we are just, spending our time with nothing that is coming with any responses to our needs. The only good thing for our case is that we have now our approach about the special interest declaration backed up by the regulation. That's gonna eventually help us in the case that we have in the ECJ, but that's the only thing that we can get from this proposal. By the way, the boxer in the picture is my dog, so she's been used in the presentation. Thank you very much.
So actually, this is a question to the whole panel, because I read actually the submission of the Court of Europe, and you only ask 5,000 euro damages, which is very low. I would think, it's much more, but only 5,000 euro. And I wonder, because the whole question now before the European Court of Justice turns around the fact, is the dog luggage, or did they have to make a special declaration? But wouldn't it be extremely easy to say, because now with the new Court of Justice saying oh, you can recuperate for immoral damages, so, wouldn't it be easier than just to drop all that and say, well, I lost my dog, you know how much this dog meant to me? That is worth at least 5,000 euro. Wouldn't it be just much more easy to say that?
But the moral damage is is going to be limited as well by the regime of the Montreal Convention, right?
Sorry, say again?
The moral damage is going to be limited by the Montreal Convention regime as well.
Yeah.
So that's they are trying to break the regime, the limit of the Article 22 of the Montreal Convention. So it doesn't matter if it's material damage or moral damage.
Yeah,
At
but
the end
now
of the day,
under the
that's the regime.
locomotion you can ask for that kind of damages, which is like contrary to the interpretation, the normal interpretation of the Montreal Convention. So don't you think it would have been easy to bring your claim? But when the time you brought that claim, lauda motion was not there yet. So, but would it not be easier now to bring that claim under the lauda motion?
In
No?
Spain, the contract is going to be governed by the Montreal Convention, so
Yeah.
the limitation is going to apply either way. I don't know if
Okay.
you have a different view, Sergi, but I think that limitation would apply for sure.
Michael, do you want to show your pictures now? Because
Yeah,
I know
exactly.
like
Right
you
on
did
time.
a lot of work on it, so maybe you want to show your pictures? Yeah? No, well, the ones you wanted to show, you said I got pictures and I want to show them. Oh yes, that's the musical instruments. That's it? Okay, that's it. Is there any observations you make to each other's presentation? Is there any observations you want to make to the presentations of your panelists? No? Yeah? You? Yeah, we've got a few minutes left. Is there any questions from the audience? Yeah. Could somebody bring only one? Yes. We're not running out of time.
Thank you. I am R.K. Singh, Rajesh Singh from India.
Yeah.
And my question is with respect to European regulation. I just want to understand a couple of things on just two things. Is there any restriction in Europe in terms of the baggage, the carriage of the shopping items in terms of weight? Because we had an Indian experience where somebody bought 2 cases of champagne, something cost weighing more than maybe 30 kgs. And it was a struggle because we don't have any such regulation. And he wanted to load it as a shopping item, which actually impinges also in a way on the aircraft weight, and there is safety issue also involved. So I just wanted to understand whether there is any such regulation. Number 2 is there any regulation in Europe in terms of the number of passengers on a particular flight who can ask for the wheelchair? Because there is a growing tendency we find that there is some sort of incentive in asking for a wheelchair, because then you easily cross the immigration, you easily cross the security lines, so people feel incentivized in asking for a wheelchair. So I wanted to understand out of any of the panelists that regulations in this regard. Thank you.
Somebody wants to answer?
I can talk about the champagne if you want.
Regarding the first one, I can only say that I forgot to bring, I forgot in the overhaul compartment some chocolates that I was bringing for Laura. So that's all. They were not very big.
No, but the multiple personal items with the shopping bag, the example that I mentioned, that was in the 2013 draft, and that has been amended to 1 personal item in the current text. So that is how that changed. And so that's still not regulated and depends on your contract of carriage still. That's not included in it. It's just 1 personal item.
But let me qualify this quickly from a purely domestic viewpoint. In Spain, we have an internal law that specifically, and it was changed to specifically state that items that you had bought in the duty-free shop, you can carry on, you can take them on board. Now, if you show up with 2 champagne cases, I very much suspect, well, probably it'll depend on the factual situation. If the flight is free and I mean there's still space, probably the crew will look a little bit strangely and not say much. But if the flight is full, I could imagine a situation where the flight crew alleges security, safety issues, things like this. But it would be a case to be brought to the court because we have a domestic provision that specifically allows you to bring free of charge whatever you bought at the duty-free shop.
Claudia, if I'm not mistaken, there's also something in the new proposal on this. Do you know anything about this?
Actually, I'm not sure.
I thought I read that also the new proposal would foresee that whatever you were buying. Does somebody know this? Can somebody confirm this?
I'm not sure about the new proposal, but this is also something that the airlines could regulate in their terms and conditions. So this may be something that the airline would have to take care of themselves.
Maybe you mean the 2013 draft, and not a new one, so that's out.
Because, as you know, like the real text is not out, and we all have to have it from whatever is said in the press. We have not seen the text yet.
The text is on. It's online.
Okay,
yeah, no, it's online.
I've been partying too much here in Rome, I think.
Yeah.
Okay, can we have one more question? Not more question? Still, no, okay. Then there was nothing more to thank Laura, first of all, for organizing this wonderful conference, and my whole panel for staying so much in line with the time. Thank you very much. You're very disciplined, and I thank you very much. Thanks.